Hi everyone, I'm Howard Snader. I'm a board certified expert in criminal law and I practice here in Arizona. In today's video I wanted to take some time just to go over the differences between what is commonly referred to as an expungement and what we in Arizona call a motion to set aside. Every day I'm asked, can I get my conviction expunged? And the simple answer in Arizona is no. With one small exception from the recent changes in law regarding marijuana possession, expungements are not available. If you do have a prior conviction for a marijuana possession case, yes, as of the change in law in January and what should be practically in effect that you can file the motions as of July, you can file for an expungement. But other than that, you're stuck with Arizona's motion to set aside. Now, the big difference between the expungement that you may hear about and a motion to set aside is what is available on a background check. Normally, expungements mean just that. The record is expunged. There's nothing viewable to the public. On a motion to set aside, the conviction is still there, the punishment is still there, and then the motion to set aside and hopefully the court's ruling that they granted the motion will still all be part of the public record. The important thing is not only is the motion to set aside granted, not only is it available so everyone can see that you've been rehabilitated and the court agrees the conviction should be set aside, but what's really important is once that order is entered, you honestly can tell people you do not have a conviction. And that's really important. In Arizona, when the order to set aside your conviction is entered, it means you should not suffer any penalties or disabilities from the conviction. Now, in the practical realities of our world, I still have clients that have trouble getting rental applications, even mortgage loans, things like that. Everything is done with a background check, so if there's any blemish, it could pop up. But the point of the statute, the actual wording of the statute is you shouldn't be suffering from any penalty or disability as a result of a prior conviction once it's been set aside. Really, the first question that you have to ask is what cases can be set aside. And in Arizona, it's almost everything. So unless your prior matter involved a dangerous crime or used a deadly weapon or dangerous instrument, unless it was a sex crime, unless it was a few other crimes that are specifically excluded, you can petition the court to have your conviction set aside. You can make that application after you're completely off paper. Well, if you're out of prison, you have to have an absolute discharge from the prison. If you're on probation, you have to be completely off probation. It usually means that restitution must be paid in full. All fines and fees have to be paid in full. Not always, but it's highly recommended you do that. It just makes the process go a lot smoother. The other thing that you need to understand is setting aside your conviction is different than having your rights reinstated. When I do the motion on behalf of my clients, I'm asking that the conviction be set aside. I'm asking that their rights be reinstated, and where possible, gun rights are a separate issue, and I ask that those rights also be reinstated. So you have the set aside of your conviction, you have the reinstatement of your rights, and you have the reinstatement of your gun rights. 3 separate requests. For those of you that may have been convicted of a Class 6 undesignated, what we call an open-ended offense, I've heard it called a wobbler in some other jurisdictions, it's really important that before you do the motion to set aside your conviction, you want to make sure that it's actually been reduced from a felony and formally reduced to a misdemeanor. That way what you're requesting is the set aside of a misdemeanor conviction. It's happened, I've seen it happen, where the court sets aside the conviction and the conviction they set aside was the felony, and that's what sticks on the record, and it's hard to go back and unwind that. So, when possible, have the felony reduced to the misdemeanor and then file all the requisite paperwork to get everything else done. Now, a lot of people say a motion to set aside can't be too hard. I'm done. I've done everything the court asked me to do. And they file what in most jurisdictions is literally a one-page piece of paper that says, I've done everything, please grant my request. Again, a lot of times they forget to ask about the constitutional rights. They forget to ask about the gun rights. They certainly don't ask about designating offenses a misdemeanor where it's legally possible. The problem with that application is that's what's in the court file. And it's usually insufficient for the judge to work off of and grant the request. If you come into my office, if you go to any experienced criminal attorney's office, I would like to think they would do what I do. Sit down with my client, put together a packet for the judge, get us the character letters, show us proof that we can show to a judge that actually shows you're not the person that committed the crime at the time you were convicted. Give the judge no reason to deny your application. And in those very few cases where we've lost the first go-around, we've already submitted all the information, the judge denies it, the judge will say why it was denied, and now we can, in short order, go back and try and make good, try and prove up to the court why his belief or her belief in denying that request was wrong. It just gives us a better starting point when we reapply. When you're ready to make that leap forward, when you're ready to try and get your record cleaned up, give me a call at the Snyder Law Group. We've been doing this for a long time, and we've helped out thousands of individuals at this point, and I want to be the attorney helping you. Thank you.